5 citations to cases that don't exist is not a rounding error in a legal brief. It is a material breach of the judicial ledger that has left a Clayton County prosecutor in a state of reputational insolvency.
So before you sit down,
Yes,
there's
sir.
one more thing I need to ask you about, unfortunately. In reviewing the trial court's order denying the motion for new trial, there are at least 5 citations to cases that don't exist. And there's at least 5 more citations to cases that do not support the proposition for which they're cited, including 3 quotations that don't exist. My understanding is that you prepared the order for the denial order for the trial court. Were those citations in the version of the order that you submitted to the trial court?
No, Your Honor, I do not believe so. They were not. I did prepare an order. That order was revised.
So those non-existent cases were cited in your initial brief opposing the motion for new trial.
Your Honor, I'm not aware of that, but I would be glad to research that and provide the court with a supplement.
Okay, we'll get a briefing order out direct.
We are witnessing a systemic failure of internal controls, where a senior auditor of the law has been caught cooking the books with artificial intelligence, submitting ghost assets in the form of fake legal precedents to the Georgia State Supreme Court. While the district attorney claims a total ban on AI infrastructure, the prosecutor's own response reveals a management override that suggests she plans to keep using the very automation that just liquidated her credibility. This is the phantom precedent audit, and for Camila's house, we are documenting the moment where the legal scaffolding of Georgia was nearly collapsed by a chatbot's hallucination. I am Camila Motado, and this is Camila's house. As a certified public accountant focused on forensic verification, I approach every court filing like a statement of financial position that must be reconciled against primary source data. In a standard audit, if a firm provides 5 receipts for transactions that never occurred, you don't just triple check next time. You issue a disclaimer of opinion and notify the regulators of potential fraud. Today, we are performing a forensic integrity audit on the Clayton County District Attorney's Office. We are analyzing the material inconsistency between Prosecutor Deborah Leslie's submission to the Georgia Supreme Court and the statutory reality of the cases she cited. We are documenting a scenario where the audit trail led directly into a digital void, leaving the Chief Justice to perform a hostile takeover of the proceedings to preserve the sovereign integrity of the court. The operational breach occurred during the appeal of a high-profile murder conviction, where the Georgia Supreme Court discovered at least 5 citations to cases that do not exist and 5 more that did not support the propositions for which they were cited. From an investigative standpoint, this is a total reporting failure. Justice Nels Peterson didn't just ask for a supplement. He performed a forensic extraction of the truth in open court, forcing the prosecutor to admit that she prepared the order that contained these non-existent assets. In accounting terms, this is a misappropriation of authority. By presenting AI-generated hallucinations as certified legal facts, the prosecutor has impaired the brand of the DA's office and created a high-risk liability for the state's entire criminal justice portfolio. This infrastructure conflict reaches a boiling point when you audit the internal policy of the Clayton County DA. District Attorney Tasha Mosley has issued a direct disclosure stating that her office has a clear policy that AI should not be used. She has labeled the incident a violation of ethical standards. However, when we perform a due diligence review of the prosecutor's subsequent affidavit, we find a compliance gap. Deborah Leslie told the Supreme Court that she would implement a firm requirement to verify AI-based tools in the future. As a CPA, I track the consistency of management. If the CEO says the tool is prohibited, but the senior partner says she will use it better next time, you have a systemic control failure. It suggests that the policy ledger is being ignored by the very people tasked with enforcing it. The social and professional cost of this digital default is currently being calculated in the form of potential sanctions. The prosecutor is facing a grievance with the state bar, a loss of privileges, and a potential career liquidation. In the world of professional liability, Using a black box algorithm to generate sovereign documents without primary source verification is an act of gross professional negligence. As trial attorney Tom Church noted, while AI is a significant tool, it comes with a fiduciary responsibility to double-check the data. The Chief Justice himself warned in his State of the Judiciary address that the power and reach of AI must be met with vigilant oversight. The Clayton County DA's office has failed that stress test on a global stage. We must also audit the information asymmetry created by this incident. Every case currently being managed by this prosecutor is now a contaminated asset. If she used phantom precedents in a murder appeal, the defense auditors for every other conviction she secured are now going to perform a full-scale forensic review of their own files. This is a litigation contagion that could force the refinancing of years of legal work. The opportunity cost to the taxpayer to re-audit these cases will be measured in the millions. This is what happens when efficiency is prioritized over integrity. The short-term gain of an automated brief results in a long-term reputational liability that bankrupts the institution's trust. My forensic verdict is that the Clayton County DA's office is in a state of operational arrears. You cannot have a management team that is out of sync on the use of disruptive technology. The prosecutor signaling that she will not stop using AI is a material default on her DA's own policy. Until the board of the State Bar performs a hostile takeover of her professional license to ensure compliance, the Georgia Supreme Court remains at risk of receiving fraudulent data. The phantom cases are the visual proof of a failed internal control system. I want to hear from you. Should AI-generated hallucinations result in the immediate termination of a prosecutor's career, or is triple-checking a reasonable settlement for the error? Does the management disconnect between the DA and her staff represent a systemic risk to Georgia's legal system? Let me know in the comments. Your perspective is the only audit that matters when the integrity of the court and the privacy of our laws are sitting on the negotiation table. I am Camila Motado, and this is Camilo's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.